jury has reached their verdict. The defendant is present. Is there any reason not to bring the jury back? Defense?
No, Your Honor.
State?
No, Judge.
All right, bailiff, we can have the jury return.
Yes, Your Honor.
Thank you. Juror number 10, I understand you are the foreperson. Is that correct, sir?
Yes, ma'am.
You've reached a verdict?
Yes, ma'am.
You have the verdict form?
Yes, ma'am.
You can hand those to my bailiff. Thank you, sir. The defendant wants to rise. Defense attorney, I will have the clerk publish the verdicts.
In the Circuit Court of the 6th Judicial Circuit of the State of Florida in and for Pasco County, case number 2014 CF 005586 AXWS, State of Florida versus Adam Matos. Indictment for count 1, murder in the first degree. Verdict. We, the jury, finds as follows. The defendant is guilty of murder in the first degree as to Nicholas Leonard as charged in the indictment. So say we all, this 16th day of November 2017, signed the foreperson, juror number 10. Indictment for count 2, murder in the first degree. We, the jury, finds as follows. The defendant is guilty of murder in the first degree as to Megan Brown as charged in the indictment. We further find the defendant did possess, display, use, threaten to use, or attempt to use a firearm. We further find the defendant did actually possess a firearm. The defendant did discharge a firearm. The defendant did discharge a firearm, causing the death or great bodily injury of Megan Brown. So say we all, the 16th day of November 2017, signed the foreperson, juror number 10. Indictment for count 3, murder in the first degree. We, the jury, finds as follows. The defendant is guilty of murder in the first degree as to Gregory Brown as charged in the indictment. We further find the defendant did possess, display, use, threaten to use, or attempt to use a firearm. We further find the defendant did actually possess a firearm. The defendant did discharge a firearm. The defendant did discharge a firearm, causing the death or great bodily injury of Gregory Brown. So say we all, the 16th day of November 2017, signed the foreperson, juror number 10. Indictment for count 4, murder in the first degree. We, the jury, finds as follows. The defendant is guilty of murder in the first degree as to Margaret Brown as charged in the indictment. So say we all, this 16th day of November, 2017, sign the foreperson, juror number 10.
All right. The defense wish to have the jury polled.
Please, Judge.
All right. Ladies and gentlemen, we're going to poll the jury. The clerk will call your seat number, and it's a yes or no answer. She's going to ask if the verdicts that she has read are in fact your verdicts. If they are, please say yes. If they are, say no, and she'll do it by seat number. Madam Clerk?
Would you like me to go each count one after the other?
No, we'll just do it as a whole. That's fine.
Okay. Juror number 1, is the verdict rendered your verdict?
Yes.
Juror number 2, is the verdict rendered your verdict?
Yes.
Juror number 3, is the verdict rendered your verdict?
Yes.
Juror number 4, is the verdict rendered your verdict?
Yes.
Juror number 5, is the verdict rendered your verdict?
Yes.
Juror number 6, is the verdict rendered your verdict?
Yes.
Juror number 7, is the verdict rendered your verdict?
Yes.
Juror number 8, is the verdict rendered your verdict?
Yes.
Juror number 9, is the verdict rendered your verdict?
Yes.
Juror number 10, is the verdict rendered your verdict?
Yes.
Juror number 11, is the verdict rendered your verdict?
Yes.
Juror number 12, is the verdict rendered your verdict?
Yes. All right. Thank you, ladies and gentlemen. At this time, as we discussed when you were originally impaneled, the verdicts in this case were for murder in the first degree, which entails that you as a panel will have to make a decision on the sentence involved in this matter. We are going to begin that on Monday. You'll be released today. You'll have Friday, Saturday, and Sunday off. I'm going to have you come back on Monday at 9:30, and we'll begin the second phase, the sentencing phase in this matter. Again, you will continue not to read, talk, tweet, blog, or anything about the case. You are still the jury deciding the second phase of this matter. So although you have made a decision on the guilt of the defendant, the sentence could be affected by you reading something or hearing something or talking to somebody about this. So at this time, I'm going to go ahead, your notes, your jury instructions, we're going to keep. They'll be back. You will need those for the second phase, so we'll have them right back here. You want to put them in the envelope, and they'll be right back on your chair when you get back here on Monday at 9:30. As I told you, I believe that we are a day ahead of when we originally had said that we would go through. Depending on how the testimony goes on Monday, my thought is that on Tuesday I will do the exact same thing I did today, which is I will bring you back on Tuesday, I will instruct you on Tuesday, and you will begin to deliberate. So I'll give you more information on Monday before you leave, because I'll know after it goes on Monday how the timing is. But right now, my guess is that you'll be deliberating for that matter on Tuesday. And so at this time, you are released. Keep your jury badge. I'll keep everything else. And we'll see you in the jury pool room at 9:30 on Monday morning. All right? Again, keep that number with you if there's any issues, okay? So at this time, I'll thank you, and I'll release you for the day.
Jurors out of the presence of the court, Your Honor.
Thank you. We can be seated. We have a few more things to talk about. All right, what I'd like is, for the individuals who are going to be handling second phase, to be here at 8:30 tomorrow morning. We'll discuss the jury instructions so we can go over them and make sure that we have any disagreement at least discussed and reviewed before we begin on Monday. There's a part where I have to read them an instruction about what they're going to do, and I want to make sure that we have all that agreed to. Defense, how many witnesses do you believe that you'll be calling? I'm not holding you to it, I mean, just a rough ballpark figure.
We have listed 12, I believe. I don't think any of them will be that long.
Okay.
We do have a Skype session scheduled Monday, 3 to 5.
Okay.
If I'm not wrong. And I'm assuming the openings aren't that long.
Okay.
I believe we can probably get through most of them, if not all of them.
Okay, and I have spoken to Court Technology. They've already talked to me this afternoon. They came in. The state's going to remove the big TV so that they can bring in their equipment and make sure that it's ready when your Skype is ready. So,
I believe they've already tested it
Right.
last week.
so they just need the big TV to be gone, and the state has indicated they'll take it with them today. So we should have it. They may even bring it in tomorrow and set it up so we know it's here, double check again. So, state, if you have any additional witnesses that you'll be presenting in penalty phase?
Not at this stage of the penalty, Judge.
Okay. The only other thing that we'll have to work through, and I'm sure you'll have that for me tomorrow, is what mitigation or mitigators you want me to put in. If you can kind of have an idea.
Yes.
I'm sure in your head you've got them kind of worked on, but if you can shore that up, because we want to make sure that we have the jury instructions correct. But again, I don't think that part of the jury instructions, the final instructions, we'll do until Tuesday if we can get through everything on Monday. So, I mean, the introduction part, the explanation of how we're going to get this done and all of that, that doesn't have the mitigators in it. That just says, we just talk about them in general terms, but the final instructions, we'll have to have those in there. And of course, anything else you think is mitigation part will be in there. So is there anything else that the court needs to discuss today in reference to what happened for the rest of the last 2 weeks? Anything, State?
Judge, I was just going to ask the court, the instruction and the aggravator listed by the state is the prior violent felony. The instruction refers to a conviction, and so based on that, I know the jury having the verdict is one thing, but if the court would adjudicate Mr. Matos as to each count,
Okay.
so that it's a clear record as to our argument as to his conviction, there's no ambiguity in the fact that he is in fact being convicted, we would appreciate that.
Okay. All right, if I can have the defense and Mr. Matos approach the podium. Mr. Matos, at this time, in case number 14-CF-5586, the jury having returned a verdict of guilty on count 1, murder in the first degree, count 2, murder in the first degree, count 3, murder in the first degree, and count 4, murder in the first degree. I now adjudicate you guilty on all 4 counts. Sentencing will begin on Monday, as I just went over. Your lawyers are ready to go on that. And you'll be remanded. You had no bond up to now and will remain on 0 bond on all 4 counts. And I will adjudicate you guilty, and the sentencing part of that will begin on Monday. Defense, do you have any questions?
No, Your Honor.
All right. So at this time, we'll be in recess until tomorrow at 8:30 to discuss the penalty phase instructions, and then Monday we'll begin the actual penalty phase. Mr. Matos does need to be brought over tomorrow. He does not have to be dressed up if he doesn't want to. He can save his suits for next week. There's not going to be any jurors here. I'm not saying you wouldn't be dressed out. I'm just saying if you don't want to wear a tie and a jacket, you can just wear, some pants and a polo shirt. It's up to you. It's whatever you want, okay? It's completely your decision. I'm just saying that the jurors won't be here. they're not supposed to be watching anything or seeing anything, so you can discuss that with your lawyers, but you don't, if you want to come in, you're stuck in the jail, that's fine. If you want to wear something less formal, you can do that too, okay? But it's completely your decision. Any other questions?
Judge?
Good to go?
Yes.
All right, we'll be in recess until tomorrow morning. Thank you. So can you make your own? We have 641. And I have